We'll now move to item 1, which is a closed session conference with legal counsel regarding consideration of a proposed notice of intent to remove Sheriff Corpus from office and of initiating procedures to remove the sheriff from office pursuant to section 412.5 of the San Mateo County Charter. As reflected in the memorandum and related materials for item 2 on the agenda, the proposed notice of intent to remove the sheriff was sent to the sheriff and to members of the Board of Supervisors on Monday of this week. At that time, the sheriff was informed that unless she objected to the public disclosure of the notice of intent as redacted to protect personnel information regarding third-party employees of the county who are peace officers, a redacted version of the notice of intent would be released. I've been informed by the county attorney that the sheriff has in fact objected to the public release of the redacted notice of intent. Is that correct, County Attorney Niblin?
Yes, Mr. President. I'd note that on Tuesday of this week, attorneys from the Murphy Pearson law firm, who actually are here today, which represent the sheriff, they informed me that the sheriff does in fact object to the public disclosure of the notice of intent. Because the sheriff has objected to the public sharing of the notice of intent to remove, it's my advice that the Board of Supervisors not discuss the contents of the notice of intent in open session, and that the board move to closed session to consider and discuss the proposed notice of intent.
Okay, we'll now move to closed session. After the board is deliberated in closed session, we will return to open session to take up item 2 on the agenda. With that, we'll move to closed session. Thank you.
Thank you. The board is currently in recess and the time is 1:34 p.m. We'll resume in about 30 seconds. Members of the public, we're back in open session. The time is now 2:25 p.m. And for the record, all the supervisors are present. And Mr. President, I did receive one return comment. I'll be very quick. It's from item number 1 from Kay Bonnie. Just to summarize, she wants the notice of intent to the public released and not be withheld. So back to you, Mr. President.
Thank you very much. The board has completed its closed session deliberations and will now move to item 2, which is to consider a resolution to confirm the removal procedures that the board had adopted pursuant to section 412.5 of the county charter to adopt and approve the issuance of a notice of intent to remove the sheriff for cause and to initiate removal procedures against the sheriff pursuant to section 412.5 of the county charter and to direct staff to provide Sheriff Corpus the adopted and approved notice of intent to remove. County Attorney, can I ask you to please say a few words to introduce and explain this item?
Yes. Thank you, Mr. President. I first want to report out of closed session that the board considered the notice of intent to remove the sheriff in closed session. As noted in the board memorandum that accompanies this item, the notice of intent concludes that the sheriff engaged in multiple acts of misconduct that, if true, would support removal from office based on causes set forth in section 412.5B1 of the San Mateo County Charter, which is a violation of a law related to the performance of the sheriff's duties, 412.5B2 of the Charter, which is flagrant and repeated neglect of duties, and 412.5B5 of the Charter, which is obstruction of an investigation into the conduct of the sheriff. During the course of deliberations, the board reviewed the notice of intent, and the board didn't identify any portions of the notice of intent that, in the judgment of the board, should be removed or revised. I also want to flag that the removal procedures, the draft removal procedures that were originally presented to the Board of Supervisors on April 8th, 2025, were revised based on guidance from the board and input received from stakeholders, including the Kecker Van Ness law firm, Kecker Van Ness Peters law firm, the Murphy Pearson law firm, and guidance from the board. And they came back to the board for consideration and adoption at the board's meeting on May 6th of 2025. At that meeting, the board's motion to adopt the procedures modified only section I46 to read as follows. that the board will propose to the sheriff a list of at least 3 neutral hearing officers with experience in public safety officer disciplinary matters available to timely preside over the removal hearing, with a preference that such hearing officer who otherwise meets these criteria be a retired judge. The resolution that the board is asked to consider adopting today confirms that the motion approving the removal procedures on May 6, 2025 only modified that section I-46, while all other provisions, including those related to the officer presiding over the pre-removal conference, remained unchanged from the text of the removal procedures presented to the board on May 6, 2025. And just to clarify, those procedures that came to the board on that date set forth that the pre-removal conference officer would be, at least in the first instance, the county's chief probation officer. Finally, as I mentioned, the board considered and discussed the notice of intent in closed session, since the sheriff objected to the public release of this document. However, the board determined that it should take action in open session on the document, even though board members are limited in what they can say about the notice of intent, given the objection to the document being made public. The resolution pending for board consideration states that the notice of intent constitutes a written statement of alleged grounds for removal, as required by Section 412.5 of the Charter, and the removal procedures approved by this board. Under the applicable authorities, a 4/5 vote of the board is needed to adopt and approve the issuance of the notice of intent and to initiate the removal procedures. I'm at this time available for any questions that the board may have. I also want to note that attorneys from the Kecker, Van Nest, and Peters law firm are available for any questions that the board may have for them. And I would note that Ms. Little is the partner who is managing this engagement, and she's and all of her colleagues are available should there be questions. So with that, I will conclude subject to the board's questions.
Great. Are there any questions for Mr. Niblin? Vice President Corso.
Thank you, President Canepa. County Attorney Niblin, can you please explain the reasoning why the sheriff is able to object to the public's ability to see the notice of intent?
Thank you, Supervisor Corso. Yeah, there were a number of laws that are set forth in the penal code, that are set forth in the evidence code and in POBAR and other places that speak to the privacy of peace officer personnel records. It's been argued by Sheriff's Counsel that these various laws apply to the sheriff. And I myself believe it's arguable whether these laws actually apply in this context. But in an abundance of caution, we've structured this process, and we are moving forward in this process on the assumption, again, in abundance of caution, that those laws would apply, recognizing, again, there are arguments that they don't. We believe that this is the best way for us to keep this process on track and to minimize the opportunity for it to come off track for what would otherwise be collateral issues.
Thank you. And will the NOI ever be made public, and if so, when?
The allegations, the materials in the NOI, insofar as allegations are confirmed through that process, would be made available at the and publicly released at the end of the entire administrative process.
Thank you.
Thank you so much, Vice Chair. Supervisor Spear. Okay, another question. Thank you so much, Mr. Niblin. Just so it's clear for the public and for this board, if the board were to take action today to adopt a notice of intent to remove and to initiate these proceedings, can you walk us through the next steps?
Thank you, Mr. President. Maybe I can touch on sort of the immediate next steps if the board were to approve the issuance of the notice of intent. If that were to happen, staff would serve the sheriff with a copy of the notice as approved by the board, along with a statement that the board has initiated the removal process, and a statement that within 5 days after receipt of that notice, the sheriff will have the opportunity to appear at a pre-removal conference. Under the removal procedures that the board has adopted, the pre-removal conference would be held with the county's chief probation officer. The pre-removal conference will be recorded unless there's an objection to the recording of that conference. The individual presiding over the pre-removal conference after that conference would provide the board with a written recommendation regarding whether to remove the sheriff. After receiving that recommendation, the Board of Supervisors will meet as soon as practicable thereafter to render its decision to either sustain or reject the recommendation that you all would receive. Any action to remove the sheriff would require a 4/5 vote at that time. A vote to remove the sheriff would be subject to appeal by the sheriff to a removal hearing before a hearing officer. And this hearing would be open to the public unless the sheriff were to request a closed hearing. So those are kind of the immediate steps that would follow from today if the board were to take action to initiate.
Great. Thank you so much. Any additional comments or questions? Supervisor Spear.
Mr. Niblin, will the decision by the pre-removal hearing officer be made public?
The recommendation would similarly be a peace officer record. I think that the gist of it would have to be made public, but we would have to figure out how to redact it in a way that complied with the various authorities we were talking about before. In order for the board to act on it, the board, you would need to make public at least what the recommendation was.
Thank you.
Great. Any additional questions, comments? Seeing none, can I get a motion on item discussion? Supervisor Corso.
Thank you. I don't think, sorry, let me start over. I just want to take a moment to thank the members of the public who are here in chambers and on Zoom for attending today and for their interest in this process. I also want to recognize that there are many community members and county employees who are following these proceedings closely, and I understand the desire of members of the public to want to view the notice of intent. Under the comprehensive removal proceedings that the board has adopted, the sheriff is able to object to the notice of intent and has done so as stated multiple times today. And we as a board respect this process and are thus unable to make this NOI public at this time. I just want to assure the public that we built these processes to respect judicial scrutiny and due process, and we will see it all the way through. Thank you.
Great. Thank you so much. So I'm going to ask for a motion confirming the removal procedures adopted pursuant to Section 412.5 of the San Mateo County Charter, and B, adopting and approving issuance of a written notice of intent to remove Sheriff Christina Corpus for cause, initiating removal procedures to remove Sheriff Christina Corpus from office pursuant to Section 412.5 of the San Mateo County Charter, and C, directing staff to provide Sheriff Christina Corpus the adopted and approved notice of intent to remove.
So moved.
I'll make the second.
Moved by Gaucher, seconded by Supervisor Mueller. May I have a roll call, please?
Sure. Supervisor Spear?
Aye.
Thank you. Supervisor Corso?
Yes.
Supervisor Mueller?
Yes.
Supervisor Gaucher?
Yes.
And President Canepa.
Yes.
Thank you. Motion passes unanimously.
Thank you so much. Now that we've taken the action, I would like to ask the county attorney to briefly explain for our information and for that of the public what the next steps will be. We've done that. Is there anything in addition to that?
No, Mr. President, I think we've covered that adequately. Thank you.
Okay, thank you so much. I want to thank my colleagues. I want to thank the public, our clerk. With that, we'll adjourn this meeting. Thank you very much.
Thank you all. The time is now 2:36 p.m. Meeting is adjourned.